Well, today we're privileged to host a very special program entitled, What Price Justice? The Entry of Big Outside Money into Washington State Judicial Campaigns. To help us address this complex issue, I'm pleased to introduce two distinguished jurists, Justice Sanders and Justice Talmadge. They will address this topic in turn for about 7 minutes each. Following their remarks, we'll have another table talk. You're just getting to know each other, so we'll take advantage of that. And we'll talk about this topic for about 10 minutes or so, and then we'll conclude the program with an opportunity to ask the two justices questions and answers here. Justice Richard Sanders, a Tacoma native, an Eagle Scout, Highline High School Debate Club president, graduated from UW with honors in political science. Played in the Rose Bowl. That is, he played French horn in the Rose Bowl. Okay. I played saxophone there. That's a good. JD, 1969, UW Law School. Litigator and appellate lawyer for 26 years before being elected to the Supreme Court in 1995. Elected to a third term in 2004. A prolific writer and lecturer. An adjunct professor at the UW Law School, he enjoys skiing, traveling, and spending time with his daughter, Laura, who is studying in Budapest, Hungary. Recently, she visited her German host family, who had hosted her during her high school years when she was a Rotary exchange student. And our retired Justice Phil Talmadge, B.A. Yale University, magna cum laude, political science. J.D., University of Washington, 1976, where he was symposium editor of the Washington Law Review. An attorney from 1976 until the president, with emphasis in an appellate practice. He was named a super lawyer. Yeah, that's right. Excellent. There are people here who can appreciate that. A super lawyer by Washington Law and Politics. He's a member of the American Academy of Appellate Lawyers. He served for 16 years in the Washington State Senate. He was elected Justice of the Supreme Court in 1995 to 2001. He is also a prolific writer and lecturer. He and his wife, Darlene, have raised 5 children in West Seattle. And this, I love this part. So does Chris Matthews. He's still playing hardball on Puget Sound Men's Senior League, where he pitches for the Timbers. Please welcome Justice Sanders, followed by Justice Talmadge.
Well, thank you very much, President Bill, and it's a double privilege to be here today to talk to the Rotary that has done so many good things, not only here in Seattle, but across the world, and to have a reunion with my good friend and former colleague, Justice Talmadge. You know, it may come as a surprise to you, but Justice Talmadge and I don't always agree on everything. I always thought that Phil believes that there's not a problem that the government can't solve, and I always sort of believed government was the problem. So you can see that we look at issues from a different perspective. Let me begin with quarreling with the topic, what price justice, the entry of big outside money into Washington judicial elections? Well, the truth of the matter is there isn't any big money in Washington judicial elections. If anything, the problem with Washington judicial elections is that there's not enough money in those elections to wage an effective campaign. The second problem with the question is it implies that there would be something wrong if there were big money in Washington judicial elections. But there's no statistical or even anecdotal evidence that campaign contributions affect decisions of judges. This all began, or this recent debate began, I think, in 2004, when Supreme Court candidate Jim Johnson raised a record amount for a Supreme Court campaign, $539,000. This was for a statewide primary and a statewide general election. But let's contrast that with the $6.3 million raised by Governor Christine Gregoire in the same election in a state the same size as the state that Jim Johnson had to campaign. Governor Gregoire spent $4.64 for every vote that she received in the general election. Jim spent 46 cents for every vote that he received, barely enough for a postage stamp. In other words, the big spending Supreme Court candidate is outspent 12 to 1 by the governor, and the state is just as big for a judicial candidate as it is for the governor. Jim Johnson's election to the Supreme Court is significant in another way as well. It shook up the elites in the Bar Association, as well as the governor, by demonstrating that the people of this state will elect an independent to the Supreme Court who is willing to hold the governmental feet to the fire when it comes to protecting individual rights. To deal with this perceived threat, the governor proposed individual contributions to a Supreme Court candidate be limited to $1,400 per person per election. The predictable and inevitable consequence of this contribution cap was twofold. First, judicial candidates would have less money to spend, and the cost of raising that money would go up. And second, those inclined to participate in judicial elections above the contribution limit would have really no choice but to exercise their constitutional right to make their views known through independent expenditures outside the candidate's campaign. Thus, in the last election cycle, we saw judicial campaigns with less funding than before, while independent expenditures rose from nearly nothing to about $2 million. Nearly half of this money was raised by Governor Christine Gregoire herself, who was dialing for dollars on behalf of her favorite political action committee. For example, Governor Gregoire solicited and obtained $210,000 from the Indian tribes, $200,000 from labor unions, and an additional $400,000 from other sources, practically all of which were over the individual campaign cap. But having said all of this, the 2006 Supreme Court election was perhaps the most successful in the history of this state in terms of public awareness. The votes cast for Supreme Court approximated that of the U.S. Senate candidate, whereas traditionally there had been a 30% fall-off in votes between the Supreme Court and whoever led the ticket. By capitalizing on the alleged evil of independent expenditures, the governor caused to be introduced into the state legislature the misnomered Judicial Independence Act, which supposedly provides public funding for judicial campaigns. I say it is misnomered because if this bill were passed into law, and it wasn't, it would do more to destroy the independence of our state's judiciary than anything else in the last 118 years of statehood. And, in point of fact, it doesn't provide much funding. Actually, it prohibits funding of an adequate amount of judicial campaigns, making it so that no campaign will be able to spend more than approximately $85,000, which is nothing for a statewide race. Let's talk about an independent judiciary. What is it? Our founding fathers understood this very well. They were students of the Baron de Montesquieu's 18th century treatise, The Spirit of the Laws, where Montesquieu stressed the importance of keeping the judicial branch out of the executive hands. Montesquieu was worried about liberty, and he saw government as the #1 threat to liberty because there was so much power in the government. And his solution was to divide government against itself so that liberty could exist. And he wrote, "There is no liberty if the judiciary power not be separated from the legislative and the executive." And his concern was shared by the other founding fathers as well. James Madison wrote in the Federalist Papers, "The accumulation of all powers, legislative, executive, and judiciary in the same hands may justly be pronounced the very definition of tyranny. As he cast the judiciary as the guardians of our Constitution, so it would not be rendered a mere demarcation on parchment." In summary, to understand what it means to have an independent judiciary, we should ask the question, independent from what? And the answer is independent from the legislative and the executive branch. The reason we have and we want an independent judiciary is to protect our liberty from governmental excess that comes from those branches. Our founding fathers in this state thought the best way to do that was to have the judiciary not selected by one of those branches, but rather selected by the people. That was the best way to ensure an independent judiciary, whereas appointment by the governor would be precisely the opposite. But under this bill, judicial campaigns would be tightly regulated by the Public Disclosure Commission, which is appointed by the governor. There would be only $85,000 to spend. No one would have any incentive to raise more than $85,000 because the government would match that dollar for dollar to the qualifying candidate. And as a consequence, we would have free elections in name only, as there would be no free judicial campaign for those elections. If there is no judicial campaign, we will see either the re-election of incumbents, that's the good news, or the selection of successful candidates based upon the sound of their name, their ballot position, or their gender. And if that's how we're going to select our candidates, the argument will go, I predict, why have elections at all? Let's have the governor appoint everybody. And what will that do to the founder's dream that we have an independent judiciary? Thank you very much.
Thank you and good afternoon. I want to thank the Seattle Rotary for the opportunity to present this topic to you this afternoon, because too often the issues relating to the judiciary get too little attention in the media and in our public discussions. So this is a great opportunity to talk about a vitally important aspect of our government. As a former member of the Rotary over in West Seattle and a Paul Harris Fellow, I'm always happy to be around fellow Rotarians yet again, and I'm quite proud of that association over the years. I enjoy participating in events with Justice Sanders. Richard is a good friend, and I admire his candor and his vigor in articulating his views. And contrary to popular public belief, we actually do agree on occasion. And it's more often than not, believe it or not. And on one thing we do agree fundamentally, and that is the judiciary should be elected. I'm a strong proponent of the election of the judiciary. I don't believe in the appointment process. For those people that believe that you can avoid politics by having an appointment process, all you need to do is look at the appointment process for the federal judiciary and ask yourself if you want that kind of politics as opposed to what we face when people have to go before the people in a candid fashion. But I have to say we disagree fundamentally on the question of whether there should be public financing, because while there should be election of judicial officers, some of the excesses and potential for real problems need to be addressed, and one of them will be the issue of money and how campaigns get conducted, particularly for collegial courts like our appellate courts have to be. Our Supreme Court is made up of 9 elected justices. Our courts of appeals usually sit in panels of 3 judges, and collegiality of those judges is an important factor in having the judges function appropriately in serving the people of Washington State. Why public financing? Well, we need to have public financing for a couple of reasons. The first is because of the presence of money in the political system. And the second is the need, because of constitutional principles our United States Supreme Court has announced, that there be limitations on the ability of people to spend money in campaigns and on contributions, that requires a quid pro quo that includes the public financing kind of issue. We've seen in recent years an enormous increase in the amount of money spent on races for the state Supreme Court and other appellate courts. When I ran for the state Supreme Court in 1994, I spent $125,000, which was a lot back then. It was about half of what somebody would spend in an average state Senate campaign, however. $125,000 spent statewide. In states like Texas, the candidates for the Texas Supreme Court spend tens of millions of dollars. And in the last election cycle, we saw candidates spend literally hundreds of thousands of dollars, and independent committees pouring enormous amounts of money into the campaign process. The prospect is not only the now, it's the prospect of the future of campaigns in which enormous amounts of money are going to be spent for these vitally important public positions. And whether we want judges out grubbing for dollars to run the kinds of campaigns that multi-million-dollar campaigns require. The second thing that gives me concern is the temptation then in these multi-million-dollar expensive campaigns for the candidates to go out and hire consultants and run partisan-style attack campaigns against their colleagues, many of whom may run again for the Supreme Court in a future election cycle. It's very difficult for people that have squared up against one another as opponents in an election where they've spent huge amounts of money beating the hell out of each other to all of a sudden become friendly colleagues on that appellate court. That's a problem, and we need to address it. A third problem that I think is the most problematic is as these campaigns get this expensive, the candidates are going to have to ask people for money, as Justice Sanders was pointing out occurred in the last election cycle. Greater and greater reliance by the candidates for the judiciary on interest groups to get money to run their campaigns for the state Supreme Court or for the Court of Appeals becomes an enormous problem. We want people in the judiciary to be impartial. We want them to come to the bench with their backgrounds, with their experience, with their knowledge, with their insights, and particularly on collegial bodies, it's going to be a diversity of people. But do we want candidates who've been out campaigning, asking interest groups for money, and those interest groups don't give that money, by the way, without a quid pro quo from the candidates? Do we want those kinds of concerns about the impartiality of our judiciary? For example, Justice X gets elected with $100,000 in contributions from labor unions. Business has a case on the interpretation of, let's say, wage and hour laws. The business will worry whether Justice X can really be impartial when Justice X has been beholden for that large a series of contributions from labor. And you can make the same kind of argument about a justice who was elected with business support and labor being concerned about the impartiality of that judge as well. We really don't want candidates for the judiciary making promises to run for in the process of running for particular offices. The courts must not only be fair, but they have to appear to be fair in the processing of any case that comes before that court. I know that there are examples of public financing in other states that have worked. North Carolina is one, where the public financing of appellate court races has been very effective. But we have to ask ourselves as Washington citizens, what kind of judiciary do we want? Do we want people that are truly impartial, who are not beholden to anybody, sitting on the bench, or do we want people who are nothing more than partisan political figures who have been out raising money and grubbing for dollars, sitting on cases where it would appear that they might be less than impartial when the issue comes before that court? I believe the citizens of Washington want that kind of impartial judiciary. Thank you.
Well, Justice Sanders, I think your comments about our topic were very fair and correct. I think we did probably frame it in a way that was prejudicial. But I don't think we could have asked for two clear presentations to actually get before this group what the real issues are. And I commend both of you for just a superb job. Most of you know I'm not a big fan of political debates up here at this podium, but it's fine with me if you knock each other out right there at the table. So for about the next 8 minutes or so, have at it. This is a tough one, and I think there's a lot to be discussed. So take your best shots. I'm going to ring the bell in about 8 minutes, and we'll bring the justices back up here for some Q&A. Thanks. Order in the court. Watch out, because I've got a gavel and both of these guys know how to use it. Okay, Laura.
Thank you. We have a question here from John.
The capping of the expenditures would only be a cap for the candidates themselves, would it not? And does that have anything to do with actually how much is going to be spent? You can't control the independent monies coming in. So what you're talking about capping doesn't seem to have any true impact on the amount of expenditure.
That's a very good point. In the governor's bill, the candidates' expenditures would be capped at $85,000, which renders the campaign completely ineffectual if there's an independent expenditure of $1 million or $2 million going the other way. There's no way you can get your message out.
Well, there are campaign contribution limits on what people can contribute to individual campaigns now, and those apply to the judiciary. They were based on Initiative 134 some years ago. Secondly, any public financing bill, and I don't hold any particular candle for any bill, they usually involve some sort of limitation on what people can spend from various sources that they receive. And that's I think that's the idea of this restriction, that you get the quid pro quo. You limit expenditures in exchange for some sort of matching or some sort of public participation in the financing. That's the model in North Carolina. It's the model of the presidential campaign public financing.
No.
Well, actually you can, because you can take into consideration 527 committee or independent expenditures and basically charge that against the candidate that benefits from those expenditures. So you could have that be a factor.
A question from our group. Our collective group considered the issue, and we agreed that there was a need for more financial input so that there is greater education of the public about the issues that are raised by different candidates. So the question would then be, how do we achieve that? And is there an alternative to money to do so?
That's an excellent question, because in order to have limitations on expenditures under Buckley versus Vallejo, there has to be some sort of public participation. And some people have argued that it doesn't necessarily need to be money. It could be greater opportunity to access for nothing TVW. It could be waiving of filing fees. It could be greater expenditures like the Supreme Court already does for disseminating information about the various judicial candidates. So any of those things could be possibilities in lieu of dollar contributions.
I respectfully disagree. I think that money talks, and that every election that we see or watch or participate in is driven by money. That's the only way you can communicate in an effective way with the general population. This so-called public financing bill, 90% of it is to make sure that there isn't any financing. It seems to me that the preferable answer to all this is freedom. Let people do what they want, spend what they want, say what they want. Would be my first choice. My second choice would be a public financing bill that said, all right, if you win the primary, we'll cut you a check for $1 million, period. That's the end of the public financing bill, and then let people do what they want to do. But that's not what the governor's bill is all about. It's about more and more governmental regulation to smother campaigns.
Our table discussed the problem with judges running locally and the difficulty they face when they're theoretically not supposed to talk about their political beliefs or positions as they're running. And that's appropriate. But we also know that for many people, they're confused about either who is running or who are they voting for. As an example, I know that every election that comes up, I get phone calls from friends and says, as an attorney, who are the bar supporting, or how are there ways that we can know more about the judges?
Well, these days with the White decision, judges can talk about a lot of things in the course of the campaigns, and they really don't like to talk about how they would vote on a specific case. But in terms of their general views and general philosophy, they certainly can speak to those in the public process. I was in a weird position as a former legislator. In the course of 16 years in the state Senate, I voted on damn near anything there is to vote on that was in the public process. From agriculture to zoology, we had an obligation to vote on it in the state Senate. So people could look at my record and they could make a judgment about where I was likely to come from based on that voting record over 16 years. Other people are not quite so open in terms of their backgrounds in running for a judicial position. But I think the more that people have the opportunity to talk in general terms about their philosophy, the more they have the opportunity to interact with citizens, either on television or through informational distribution by the courts themselves. I think that's healthy for our citizens to know more about the candidates for the judiciary than not.
Well, that's a variant of the most asked question that I've heard in my years on the court. How do we figure out who to vote for? And the reason that question is asked is because judicial campaigns are usually ineffectual. The candidates would love to tell you who to vote for and why, but they cannot get their voice heard. Another part of your question is, well, or what Phil said, that for the U.S. or for the state Supreme Court, every one of our opinions is published. And if someone wanted to challenge me or challenged Phil, what he would do or she would do was to pick out 5 or 6 of these opinions that they disagree with, and then get their views out about why they're right and we're wrong. And I think that's an excellent way to go about it. And it tells people something that they really should need to know about cases or issues that are of interest to them. But you have to be able to have an effective campaign to let the voters know where the judges stand. And there is differences in judicial philosophy which lead to different results. And I think both Justice Talmadge and I are very consistent in how we approach these cases, but we consistently approach them differently.
At our table, we learned about a merit appointment system that is in effect in, I think 30 states, where blue ribbon commissions give a list of highly qualified candidates to a governor from which he or she must appoint them. What's the matter with that?
Well, who are they to say it's an elitist system, you know? That there was a bill in this last legislature to amend our Constitution to have one of these blue ribbon commissions. The governor would appoint 3 or 4 people. The Bar Association would appoint 3 or 4 people. There would be 1 member from each caucus in the House and the Senate. It's just politics behind closed doors. I think that the people of the state of Washington are much more able than these insiders to select a good judge. And we've had 118 years in the state of good judges being elected, and that's the way I'd prefer to pursue it.
And I agree with that as well for the same reasons. Remember your college philosophy class when you were reading Plato's Republic, and you may recall Plato believed in a group of philosopher kings running the state. A problem with Plato's Republic, just as the problem with this commission, is who selects the philosopher kings. In the final analysis, remember who these folks will be beholden to as they decide which candidates are the better candidates than the others. I'll leave you with this one note. One of our mutual colleagues, the late Jim Dolliver, Jim probably never would have made that list. He was a politician. He was somebody who was at the right hand of Governor Dan Evans. But he was somebody that had great wisdom and great perspective, and Governor Evans was wise to appoint him to the Washington Supreme Court, where he served with great distinction. I'll take every Jim Dolliver I can get over all the theoretical selections of all the theoretical nominating commissions that there may be out there.
Thank you. Well, whatever critiques might be lodged against the current system, I think that everyone in this room will agree that the current system worked pretty well when you 2 guys were voted onto the court. So congratulations and thank you very much. Which brings us to this week's pretty good rule. Strive for excellence, not perfection. Seek quality and value in all things. See you next week. We are adjourned.
Seattle Rotary Online is made possible in part by a grant from Enterprise Seattle. For over 35 years, Enterprise Seattle has provided client-based economic development services to businesses throughout King County and its 39 cities. More information on Enterprise Seattle and how they help businesses grow and prosper can be found at www.enterpriseseattle.org. And by First Choice Health, working with the Washington Health Information Collaborative to use technology to bring better health care to patients throughout the Pacific Northwest. First Choice Health.